Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 199. We're standing on the brink of glory, aren't we? But more seriously, I've been given some careful thought as to how I wanted to mark this milestone. When I got to episode 100, I did an episode looking at the things that I'd learned during the first 100 episodes as a podcast broadcaster. Now that we're reaching episode 200, I thought I'd look slightly more broadly and things that I've learned by virtue of being an employment lawyer for the last 30-something years. I cannot pretend this is unconnected to the fact that in a few days' time I'll be leaving Mayor Brown, and inevitably that gives rise to a period of reflection, I think. Anyway, what I thought I'd try and do is identify 10 key aspects to being an employment lawyer and discuss those in the podcast. It seems like a suitable end point. As I mentioned on the last podcast with Chris Fisher, he is taking over the podcast series, and so it feels like drawing a line under the podcast up to this point. But before I kick off the 10 points, and I'm going to spread these out over 2 podcasts, I should make a couple of points clear. First of all, I'm not claiming these are Harvard-level insights into the legal profession. I suspect many people would have similar points that they would make if they were asked to come up with a top 10 list. Secondly, I'm looking at matters from the perspective of a solicitor rather than a barrister. My practice area is predominantly acting for employers rather than employees. In the circumstances, I'm sure that this will affect the top 10 points that I select. So, okay, without further ado, my top 10 key points, counting down from number 10, they're roughly in order. I really can't claim that I've thought about the relative placings of, point number 7 to point number 6. An awful lot. But anyway, here's how we start. Number 10. Think carefully about how you explain things to people. Lawyers' lives are full of explanations. We need to explain things to our clients. We need to explain things to courts, tribunals. We need to explain things to the other side. We have to explain things to our colleagues, whether they're working as part of a team or they're a junior lawyer whom we are providing training for them. Think about what works as an explanation. You're going to have to provide the same explanation over and over again in your career, whether it's explaining what amounts to constructive dismissal or the test for a TUPE transfer. You're going to provide the same analogy, the same phrases, the same explanation. Find something that works based on the typical reaction of the person you explain it to. If it's an explanation you're provided to a junior lawyer, is that the same explanation that you'd give to a client? Listen when other people explain things. See what works. I think this is particularly important with clients who may have a limited interest in the concept that you need to explain to them, and they'll want an explanation that works efficiently and succinctly. But if it's something that's going to take some time to explain, having worked out how you're going to explain it efficiently, flag up ahead of time it's going to take a few moments to explain. I think in this way you signal to the client that it's worth being patient with you during your explanation. Equally, you are saying, I know what I'm doing. I'm not just asking you to listen to me, blabber on. This is important. And that is also a very reassuring message for a client. Number 9. Our advice, our professional advice, starts with the law but ends with the practicalities. It's one of the mantras in my life that clients assume that lawyers know the law, but I think this confidence is often misplaced. So if you have any spare time, reminding yourselves of the provisions of a particular area or of a particular topic of law is never a waste of time. But the more I go on, the more I think that the sort of work that solicitors do needs to start with a legal analysis. It needs to be properly grounded, but then it needs to move to practicalities sooner rather than later in order to be able to give pragmatic advice and get to a solution. This sometimes means following the law closely. Other times, it means stepping back a bit. Let me give you an example. A number of years ago, I was asked by a barrister's chambers if I could provide some employment advice to them. They didn't have any in-house chambers employment expertise. The question they wanted to know was whether it was permissible to discipline a senior barrister on the grounds of unlawful harassment, where the junior barrister, who had allegedly been unlawfully harassed, did not want to make a complaint. And there was no two ways around it. They were very clear they did not want to make a complaint. There had been an argument during which the senior barrister had said some pretty inappropriate things to the junior barrister. As I say, the junior barrister, of their own will, freely, was making it clear they did not wish to make a complaint. And Chambers was worried about its legal responsibilities and asked me to advise on that particular legal question. Well, we went to Chambers to have a meeting, and at the meeting, as our work was being scoped out, I asked what the row had been about that had actually led to this problem in the first place. It turned out the senior barrister was close to retirement. They were in a management role and felt that the management role and the work they were doing in it was simply not getting the recognition it was due. The senior barrister was frustrated, I was told, that the junior barristers appeared to be disrespectful and rude to that barrister in the final stages of that barrister's membership of Chambers. The meeting, therefore, I was having with essentially my clients, developed into a discussion whether a solution could be identified that met the junior barrister's wishes not to make a formal complaint, enabled the senior barrister to apologise genuinely to the junior barrister, not because an apology was required of that barrister, but it was something they genuinely wanted to do. And I was told that the senior barrister was extremely remorseful for what had happened, whilst maintaining it was something that had been triggered by the junior barrister. So, but the other thing that we discussed was whether there was a way for Chambers to recognise the contribution made by the senior barrister as they were coming to the end of their management tenure in the particular set of chambers prior to going off and retiring. So at the end of the day, the chambers mapped out a plan that addressed all those things, and as far as I'm aware, it worked extremely well for all concerned. But it was a million miles away from the legal question that we were called in to give advice on. And I think it's something that you always need to be willing to do. Just because you've been asked a particular question doesn't mean the answer to that question is the answer to the issue, or it's the answer on which you should base all your advice. Point number 8. I think solicitors, I think all lawyers, but particularly solicitors, we need to be enabling our clients to be comfortable enough to share with us what they're really thinking or what they really know. I think it's extremely important to recognise that some people find lawyers unsympathetic, intimidating. I've seen this a lot when I'm advising individuals, but equally one has to recognise that witnesses for a company in a case may be equally ill at ease with talking to the lawyer representing the company. This may, of course, make a huge impact on what they say to that lawyer. They may feel under pressure to subscribe to the company's version of events. They may not want to voice support for the claimant's account of what happened. They may be desperately worried they're going to make an error, and so they want to be particularly definite about what they know. Conversely, they may not want to wish to admit they may have made a mistake. They might have done something stupid. They may be embarrassed, they may be ashamed, but you've got to recognise that. And I think if we are good at listening when our clients are talking to us, you pick up on some of those nuances. Equally, you will in turn be able to identify ways of encouraging them to be candid with you. And after all, at the end of the day, it's extremely important that before the individual gives evidence on oath, you know what they really think, and equally that your advice is based on, as far as the witnesses can make it, the truth, rather than the version of events that people think you want to hear. I had a really good example of this many years ago now, when a new client arranged to come in and see me, and she'd been referred to us by her husband, who was a client of the firm I was at the time. The advice was to do with the fact that she'd been dismissed because she'd allegedly been having an affair with her boss, and her boss's wife had found out. She denied strongly to me, when telling me about this, that there was anything in the suggestion that she had an affair. Bearing in mind that she herself was married, I could see this obviously was going to be quite a tricky issue. So I let the conversation meander. We talked about other aspects of the matter for long enough that she got to a point where she volunteered to me that she wanted to go back and correct something that she'd said beforehand. She then volunteered to me that she had in fact been having an affair with her boss. She said she was ashamed of what had happened, which is why she hadn't wanted to tell me originally. And once she told me that, I could tell her that, of course, I was not there to judge her, but to advise her. And so I could thank her for her honesty, and then we could get on with giving the advice. But I remember being really pleased at the time that I had the patience to let her talk about other issues, which, while she was clearly coming to a conclusion as to whether or not she was prepared to trust me with the truth. Equally, I knew before she told me what she was about to tell me, and there was a look in her eye, there was something I could see her sort of commit before she opened her mouth. So I knew I knew what was coming at that stage. Can't always claim that I get that, but I definitely got that one then. Point number 7. I think more mistakes are made because of time pressure than are caused by any other aspect of being a lawyer. Another way of looking at this is to say that if you're being given a reasonable settlement offer, then that should give you long enough to consider it. If you're being rushed to take an offer or rushed to take a decision without any good reason, it's probably not a good decision, or the course of action that is being urged on you may well be deeply unwise. When problems arise, you always go back and look at how did that particular situation arise in the first place. I have occasions in my career where settlements done at the door of the court sounded fine in principle, but there was great pressure to get the deal done before the case started, so the parties maybe didn't cover all of the complexities, or content to allow matters to be dealt with on a relatively loose basis. That's absolutely fine, provided the client is aware that is what is going on, and is able to make an informed decision. I remember one case which was related to a client with whom we had what might have been termed as a deteriorating relationship. Well, we'd reached the point where we were having to chase him up over our bills. The client was a former senior executive of a global international company, and he was a wily old fox. So I rang him. I was detailed off to ring him to protest that one of our bills was long overdue. He indicated he wanted to pay the bill and he was going to pay a bill and do it. He got an idea for me about how he could achieve this. He pitched a very reasonable idea for payment to me, but explained this meant we were going to get paid in euros rather than sterling. So he agreed some numbers on the phone, to which I said yes, this all sounded very sensible. And then when I got through it all, I realised he'd quietly omitted VAT and the currency rate was terrible for us. So, lesson learned. Number 6. Take your work seriously, but see the humour in it. I think it's extremely important that we recognise that most of what we do is very serious. Clients expect high standards from us. People's livelihoods, reputations, etc. can be at risk. Finding a solution that enables people to get on with their lives is often extremely important. But my personal view is it never does any harm to recognise some of the situations may have humour built into them. Showing that you find something to be amusing or ridiculous, or an unfeasible coincidence, can take the pressure off a situation. I've often found that if I'm in discussions with the lawyer on the other side of a matter, and I can find a point where I can make a joke or a comment that makes someone laugh, then you're building bridges. And once you're building bridges, you're on your way to a settlement, and that is almost always in the client's best interests. I remember coming across one of the Chambers entries for me, which went in one of the books a few years back, where someone else had been asked to comment and said that I was adept at using humour to break log jams. And I was thinking, damn, my secret's out. Anyway, since my secret is out, there's no danger in my sharing it on the podcast. So, that's the end of this podcast. Thank you very much for listening to it. Podcast number 200 tomorrow. And then we'll be doing my top 5 keys to being an employment lawyer on my next and final podcast from Mayor Brown. So thank you very much, everyone. Stay safe. And here's to episode 200. Cheers.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.